Hello everybody, you're very welcome to Law Hero. My name is Jen and I make videos about the law, and today we're continuing with our FE1 series for this year 2022, which I've been doing for 4 years now. And today we're talking about contract law. If you haven't already done so, please follow along at Law Hero IRL on Instagram. Please take a look at my website, lawhero.eu, where I have all ebooks for FE1 subjects. And if you have any issues, please contact me at info@lawhero.eu. So today we're talking about contract law, and I'm specifically looking at the October and March 2021 exams and kind of like taking a broad view on what you should prepare for those exams. And I think with contract law, the issue is people just get so muddled in what it's asking. Like, I've been giving tutoring for contract law for the last number of years, and it's so funny that people cannot pull apart the issues and they get all muddled up. So I would say in your application of contract law, you have to be very, very organized. My second tip would be take a very practical, pragmatic approach to answering the question. For example, like when you are thrown with question 1, which is usually very heavily a fact-driven question with lots of toing and froing, emails going backwards and forwards, I would say to you, firstly, go down and see who your client is. For example, question 1, March 2021, you're advising Jack. Now, on question 1, March 2021, this is like back and forth. There's a done deal ad, which is an invitation to treat. No, you're not playing with that one because I'm making a video. This is certainly not a toy you want when you're trying to make a video on contract law. No, you'll get it afterwards. So in that particular problem question, there's a lot of toing and froing. So my advice to you guys when it comes to the first question, which is not always offer and acceptance, in November 2020 it was a mistake. My advice would be to set, like, even when you're going down through the questions, number 1, figure out who you're advising, and then put, like, for example, in March question it was Jack, Paula and Sam. I would put them all separate and be like, okay, what's happening between these people? Who is the buyer? Who is the seller? Is there a contract? Is there offer, acceptance, consideration? Is there revocation? Is there a counter offer? Like, what exactly has happened? Do it very, very slowly. Like, people mess up question 1 so badly, and what happens is you lose credibility with the examiner. Like, this examiner says like many times that the application of the law is really lacking when it comes to contract law. The other interesting thing the examiner says is that there's not necessarily a right and wrong answer. There's just an answer that is less wrong. So for example, if you were able to argue, for example, in March 2021 that, he's selling the car, the guy who's selling the car for 10k, and this person replies going, would you take 9k, that you're able to argue that rather than a rejection of the invitation to treat, that could also be characterized as a counter offer capable of acceptance. Now, the person selling doesn't accept the 9k, but if you're able to theorize that it's capable of acceptance but go, ultimately it's not a contract, that shows that you have awareness, that you're able to, speak theoretically about what just happened, rather than go, there's no contract, and then moving on, because you're not showing your knowledge. And like, you show your knowledge in a relevant way, like in a short, succinct, relevant way. Yeah, the fact that this person actually sells the car to someone different to the first person that is asked is a revocation of the contract. That's not necessarily true, because revocation has to be communicated. The second issue, which I would ask you guys all to really know well, is frustration. It's such a defense in contract law, especially given the economic climate. Know it really, really well. Know the factors around frustration, like what constitutes a frustrating event. That would be the next one. Undue influence also came up. I mean, you could really piggyback off what you learned in property law for that one, so I wouldn't be too worried about it. It is a defense in contract law, but I wouldn't be too worried about it, to be completely honest. I think estoppel is always a contractual issue, and you know, promissory estoppel is an area that you have to know very, very well in both equity and contract, so I wouldn't let that go. So damages and expectation loss is an area that the examiner is really concerned about people not knowing. Now, I go through this really, really well in my ebook as to what constitutes damages. And for example, just always remember when you are speaking about damages that you don't forget about remoteness, and you don't forget about, like, did the plaintiff mitigate their loss? Those are principles that are seen in every single damages claim. The next area which I have found particularly problematic among candidates is the lack of knowledge and understanding around consumer law. Okay, Saki, you have to go out now. So the Sale of Goods Supply Services Act only applies to you would only applies where the trader or the seller is acting within the course of their business. So, for example, in that question 1, March 2021, the Sale of Goods Supply Services Act wouldn't have applied because the people involved were in a private sense. But for example, if you look at question 6, March 2021, this is business to business. Section 14, statutory warranties, for example, the goods be as described, goods be of merchantable quality, goods be fit for purpose, they can only be excluded if it is fair and reasonable to do so under section, I think it's like 55 of the Act, and then their fair and reasonable to do so criteria is actually listed in the Act. So there, for example, because the computer screens were blurry, they weren't of merchantable quality. They actually also weren't fit for purpose. So that means then that the buyer has a remedy under the Sale of Goods Supply Services Act to get a repair, refund, or replacement. The other big area that a lot of people don't really know that well is consideration for extra work done, a la Stilk v. Merrick and Williams v. Raffy Brothers. That comes up an awful lot. Sometimes the examiner will throw in some small issues, like, for example, interpretation of contracts, you know, the ability to negotiate in good faith. I saw one in November 2021, as in the definition of, I think it was like high-end tenants. That would be an interpretation of contract. And then you would look to what the intention of the parties were at the time. Privity of contract is one the examiner sometimes throws in. I don't do it in my book, but sometimes the examiner throws it in. The examiner will always put something in consumer law. I mean, it was peppered throughout the March 2021 paper. For example, they asked, half a question was asked around the unfair terms regs, and sometimes as well they will ask about mistake. Those to me seem to be the broadly the big topics. Let me just see if there's anything else I left out. Economic duress was asked in October, but I don't do it. Already covered damages. Misrep does come up a fair bit. It's come up the last 2 times. Making representations, and I mean, really in contract law, it's a bread and butter area. Representations, misrepresentations, fraudulent misrepresentations, and deceit, those kind of things, they are really good defenses in contract. Those, I would say, are the main areas. I would really focus on offer and acceptance, damages, and consumer contracts as a priority. I hope you enjoyed this video. I'll see you in the next one.